यानी इस इंडस्ट्री को कैसे बढ़ाया जाए, उसमें किसी एक के साथ पक्षपात करने का काम नहीं किया। ये जो डीकंट्रोल का मामला है, ये भी देश भर में जो इंडस्ट्री थी, जो वातावरण बना हुआ था ग्लोबलाइजेशन का, उसमें हमने जो कदम उठाया, उस कदम के चलते भी नुकसान पहुंचा है। मैं इसे स्वीकार करने में कोई मुझे दिक्कत नहीं। और इन सारी चीज़ों के चलते अब ये जो ब्याज है एचडीएफ से जो दे रहे हैं, वो ब्याज मैडम हम दे रहे हैं, देश में कोई ऐसा बैंक नहीं है, कोई नहीं है, हम ही 6% पे दे रहे हैं। यार इसके बाद जो बरगोड़िया कह रहे छोटी मिल वालों, ऐसा नहीं है इसमें कि बड़ी मिल को मिलेगा छोटी मिल को नहीं मिलेगा। इसमें समान तौर पर इसमें हम जो आपने कहा है, हमारी तो हमेशा चिंता ये रहती है कि जो ज़्यादा तनहा है उसे कैसे मदद करें। तो ऐसा नहीं है कि इसमें जो मॉडर्नाइजेशन है, जो सारा का सारा डाइवर्सिफिकेशन हमको करना है, जो हमारी ट्रेडिशनल इंडस्ट्री है उसको वाइबल बनाना है, उसके लिए क्या क्या कर सकते हैं, उसमें ये कदम भी हमने उठाया कि 6% पे ब्याज देंगे। तो मैं इतना ही कहना चाहता हूं कि जो माननीय सदस्यों ने कई तरह की शंकाएं उठाई हैं, वो शंकाओं के बारे में मैडम मैं आपके माध्यम से जरूर कहना चाहता हूं कि दुनिया में तो रोज चुनौती आती है। ये सारी दोनों सदनों में इतनी लंबी बहस हुई है, लगातार सदस्यों ने चिंता व्यक्त की है। उस चिंता के चलते, आपके दबाव के चलते भी, हमारी अपनी यानी सरकार की चिंता के चलते हम लोग लंबे यानी समय से, पिछले सत्र से इस मामले में लगे हैं। और ये जो बिल लाया है, ये सहमति के बाद लाया है। ये चाहे आपके किसान के संगठन थे, चाहे वो इस्मा और कोऑपरेटिव सोसाइटी के जो संगठन ऑर्गेनाइजेशन थे, इन सब लोगों की बहस के बाद, सरकार के भीतर जो एक्सपर्ट बैठे उनकी राय के बाद, आप सब सदन में जो सदस्य बैठे उन सब लोगों ने जो कहा, उसके चलते प्रधानमंत्री जी ने पिछले यहाँ लोकसभा में निचले सदन में इस मामले को बाकी कदम के साथ घोषित किया था कि हमको जो रिलीज मैकेनिज्म है उसे मजबूत करना है। जो हमारा शिक्षा कंट्रोल वाला जो मैकेनिज्म है वो नहीं काम कर पाया, और उसके चलते भी हमको एक दिक्कत आ, मैं नहीं कहता उसके चलते ही सारी दिक्कत आई। उत्पादन हमारा बड़ा है, हमारे किसान जो ग्रोअर्स हैं उनकी रकबा बड़ा है, हेक्टेयर बड़ा है, हमारा लगातार उत्पादन बढ़ा, हमारा लगातार कंजम्पशन बढ़ा है, सारी चीज़ एक साथ हुई हैं। और निश्चित तौर पर ये जो मैकेनिज्म है, ये जो बिल है, इसको पास यदि करेगा, मैं आपके माध्यम से कहना चाहता हूँ कि ये इसके चलते सभी लोगों से संपर्क किया है, सब लोगों से सलाह किया, सब लोगों से चर्चा और सलाह करने के बाद ये सिर्फ ये नहीं है कि हमारे हाथ में ये ताकत आ जाएगी, सिर्फ ये है कि सरकार जो नीति बना रही है उसके बारे में जो इतनी बड़ी चीज़ है, जो बरगोड़ जी कह रहे थे कि एसेंशियल और बहुत ज़रूरी चीज़ नहीं है, मैं मानता हूं कि इस देश में ये बड़ी ज़रूरी चीज़ है। शक्कर मतलब यानी मीठी बात कहो, यानी हमारे यहाँ कहावत है कि मीठा यानी गुड़ या शक्कर, तो लोग हमेशा कहते हैं कि भाई जरा मीठी बात करो, लेकिन मुझे गजब लगा कि बरगोड़िया जी बोले कि नहीं ये तो कोई ज़रूरी चीज़ नहीं, इसको एसेंशियल एक्टिविटी में नहीं डालो। आपकी ये मैं आपसे विनती करूंगा कि आपकी राय को आपको बदलना चाहिए, और ये जो बिल है इसको सब लोग
सपोर्ट कर रहे हैं। हाँ, मीठी बात के खिलाफ है पर सपोर्ट कर रहे हैं।
और उन सब बरगोड़िया जी और सब लोगों ने दबाव बनाया सारी चीज की, इसीलिए सरकार कदम उठा रही है। इसलिए सरकार ने कमेटी बनाई है, जो प्लानिंग कमेटी के सदस्य हैं श्री सोमपाल, वो काफी एक्सपर्ट है इस मामले में, और सभी मंत्रालयों को बैठा करके इसमें कमेटी बनाई है। तो ये एक तात्कालिक तौर पर जो कदम उठाए उसके लिए ये कदम उठाए गए हैं, और लॉन्ग टर्म पॉलिसी क्या होना चाहिए इसके लिए भी एक कमेटी बना करके चर्चा चल रही है। मैं आपके माध्यम से कहूंगा कि इस बिल को यह पास करने का काम करें।
जावेद जी आपका क्या समस्या है?
उन्हीं को उससे मदद मिलेगी, छोटे छोटे एक
माननीय सदस्य को मैडम ये है कि जो उनके ऑर्गेनाइजेशन है उनसे एक बार इंटरेक्शन नहीं हुआ, उनके ऑर्गेनाइजेशन में छोटे भी हैं और बड़े भी हैं। वो बरगोड़िया ने कहा था कि बड़े लोगों को, वो बड़ा आदमी तो हमेशा फायदा रहता है, बड़ी मछली जब फायदा रहती है, नेचर का काम है। लेकिन इतना जरूर है कि मैं इस बिल के साथ ये आश्वस्त करता हूँ कि जो छोटे वाले लोग हैं उनके हितों की कोई अनदेखी नहीं की जाए, उनको प्रोटेक्ट करने का काम करो।
अच्छा जावेद गौड़ा जी आप क्या कह रहे हैं? जी हाँ, एक
मैडम, this bill is brought in.
No, you spoke enough.
This bill is brought in with a specific intention of regulating the sale of the sugar, with the ultimative power resting with the director regarding the release of the sugar for sale. But in Essential Commodities Act, sugar is not the only thing. It contains and regulates all other items. But this bill is containing regarding the control of sugar. I would like to ask the Honorable Minister, do you have taken any efforts to protect the interest of the sugarcane growers? You are insisting.
Okay, let him answer.
Yes.
Are you taking
मैडम
protection?
मैडम डिप्टी चेयरपर्सन, मैं तो लगातार बताया कि जो 786 रुपीज जो है, करोड़ रुपीज जो है, वो सिर्फ और सिर्फ केवल और केवल शुगर केन ग्रोअर्स के लिए ही जा सकते हैं, उसका एक ढेला भी कहीं नहीं जा सकता। 5 रुपए हमने जो अभी बढ़ा है, ये अकेले इसके बारे में मत कहिए, 5 रुपए जो बढ़ा है वो आप सब लोगों की, और खास करके सदन में देवेगौड़ा जी ने इस सवाल को उठाया था, उनके डिबेट के बाद ही 5 रुपए बढ़ाए थे। फिर ओशन फ्रेट जो था वो पहले नहीं था, ओशन फ्रेट बढ़ाया। और ये जो पिछले ड्यूज हैं, मैंने कहा कि 95 करोड़ बचे हैं, 1000 तक करीब 200 करोड़ रुपए पिछले बार के ड्यूज थे। तो केन ग्रोअर जो है उसके हक में कई कदम उठाए हैं। ये कदम इसलिए उठाया है कि यदि इंडस्ट्री भी नहीं बचेगी और इंडस्ट्री के पास सामर्थ्य नहीं होगा किसान को देने का, तो अल्टीमेटली ये पूरा टोटल कंट्री का नुकसान होगा। इसमें एक कदम है, बहुत से कदम तो उनके हक में हमने उठाए।
थैंक यू। ना ना ना, बस बंद कीजिए अभी, काफी जी।
पॉलिसी कब तक लाएंगे? शॉर्ट टर्म से काम नहीं चलना
जी। ओके,
वो बता दीजिए।
अब आप बता दीजिए आपका सवाल क्या है।
कि आप अगर वाकई इंडस्ट्री को बढ़ाना चाहते हैं तो एक काम जो तत्काल आप कर सकते हैं, बिजली विभाग वालों से बात करके और सारे बोर्डों से बात करके राज्य सरकारों के, आप उनको बिजली बनाने की छूट दे दीजिए। बिजली बोर्ड उनको इजाजत नहीं देते हैं, उससे बिजली की समस्या का भी निदान होगा और उनकी आमदनी भी बढ़ेगी। और साथ ही साथ एसएमपी की बात मैं नहीं कहता हूं, एसएमपी आप समय से घोषित करते हैं, लेकिन जिन राज्यों में एसएमपी के जरिए से नहीं होता वहां पर पहले से ही ऐलान हो जाए तो वो गन्ना कम बोएंगे और दूसरी खेती करेंगे। लेकिन आपके भाव तब तक भी नहीं आते, आज तक नहीं आए। उत्तर प्रदेश में भाव आज तक नहीं आया है। ऐसी स्थिति में गन्ना ग्रोअर की बहुत बुरी स्थिति हो जाती है। आप कृपया पहले ही उनके मूल्य घोषित कर देंगे तो वो उतना ही जिन्स बोएंगे जितनी उनकी आवश्यकता होगी।
2 सवाल मूल्य हैं।
मैं उनके दोनों सवाल समझ गया। एक तो उन्होंने को जनरेशन के लिए प्रॉब्लम है, जो को जनरेशन है उसमें जो बिजली बनाई जाती है वो स्टेट बोर्ड लेगा, एनटीपीसी लेगी, ये एक बड़ी समस्या है। इसके बारे में हम अपने तरीके से चर्चा कर रहे हैं। एथेनॉल के मामले में भी हमारी और पेट्रोलियम मिनिस्ट्री ने लगातार संपर्क करके दोनों ने मिलकर के आगे इस मामले को बढ़ाया और उसको बहुत गंभीरता से लिया है। और दूसरा सवाल आपका जो था एसएमपी वाला, वो सीएससीपी एग्रीकल्चर डिपार्टमेंट के पास है। कौशिक जी ने पिछली बार भी ऐसा मामला उठाया था और उस बात को मैंने जो एग्रीकल्चर मिनिस्टर है उनके पास कहा था कि इसको संभव है, पहले तो कभी हुआ नहीं, लेकिन इनका एक सुझाव है कि ये जो मूल्य है यदि पहले घोषित कर दिए जाए, सपोर्ट प्राइस को पहले कह दिया जाए, ये संभव है तो निश्चित तौर पर इस पर भी हम चर्चा कर लेंगे, क्योंकि जिससे भी किसान का देश का हित हो उसमें किसी तरह के प्रयास करने में कोई दिक्कत हमको नहीं है।
और लॉन्ग टर्म पॉलिसी भी कर लीजिए।
लॉन्ग टर्म पॉलिसी के बारे में मैं बरगोदिया जी को समय तो नहीं दे सकता। निश्चित तौर पर जो तात्कालिक कदम है उसमें मैंने बहुत बताया, उनको मुतमईन होना चाहिए, थोड़ा संतोष होना चाहिए। सुनिए, आप संतोष ही नहीं होते, गजी आपका नाम संतोष गलत रखा हुआ, संतोष रखना चाहिए था। तो सीधी बात यह है कि मैंने तात्कालिक जितने कदम बताए, तो एक बात पर तो उनको राजी होना चाहिए कि जितने तरह के यानी समाधान के लिए कदम उठाए जा सकते हैं वो सरकार ने उठाए।
ओके, नाउ द क्वेश्चन इज दैट द एसेंशियल कमोडिटीज अमेंडमेंट बिल 2003 be taken into consideration. Those in favor please say aye. Those against please say no. I think the ayes have it, the ayes have it, the ayes have it, motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 and 3 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 and 3 are adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Shri Sharad Yadav ji.
I also move the bill to be passed.
Motion moved that the bill be passed. The question is the bill be passed. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill is passed. Thank you very much.
Thank you, madam.
आप ऐसे मीठे मीठे बिल लाया कीजिए तो जल्दी पास करते
ज्यादा मीठा है मैडम।
अभी दूसरा बिल भी अच्छा बिल आ रहा है, राज्यसभा के हित का बिल है। द रिप्रेजेंटेशन ऑफ द पीपल्स अमेंडमेंट बिल 2001, श्री अरुण जेटली जी।
Madam, I beg to move that the Representation of People's Amendment Bill 2001 be taken up for consideration and approval by this Honourable House. The thrust of this bill, Madam, relates to two special aspects with regard to the procedure for elections to the members of the Council of States, that's the Rajya Sabha. We've, since 1951, had a firm system where to be eligible under Section 3 of the Representation of People's Act, to contest for the election for the Rajya Sabha, one has to be an elector of that state. And under Section 19 of the Act, in order to be an elector of the state, you have to be a person ordinarily resident in that state. Now, several features over the functioning of this election system have come to notice. For one, in a large number of cases, political parties which send up representatives from various states have sent up persons who traditionally were not residents in the state, but for the purposes of election to the Rajya Sabha, got enrolled as electors in that particular state. If we do recollect, about 6-7 years ago, there was a large controversy whether this practice now requires to be changed as far as the legal system is concerned. We tried to develop a consensus amongst political parties. Some of the political parties took a particular view that a change perhaps is now required. Some people still had reservations about this. And one of the points of criticism which was made against this proposal was that this may perhaps affect the spirit of federalism, which is otherwise inherent in the fact that it's only an elector of a state who gets elected from that particular state. Under the existing system or the proposed system, it is the members of the Legislative Assembly of the state who are the electors. It is their option whom they choose to elect, who they feel can best represent the interest of the states. As against this, several arguments have been given, which I present before the Honourable House, as to why this system requires now to be altered. One of the first reasons why it requires to be altered is because in the matter of its actual implementation, a breach too frequently was witnessed. And therefore, political parties wanted to come to an honest assessment of the situation and come to a conclusion where this perhaps now requires to be altered itself. The second, that under our constitutional scheme, under Article 19(1)(e), a person has a right to reside anywhere in the country. So a person who wants to change his residence, there may be cases where people maintain more than one residence. For reasons of business, for other reasons of family, people may be residing in more than one place simultaneously. And therefore, this perhaps may not be in a position to deal with such situations, the existing situation. The third reason, which was also, besides the factor of multiple residences, that there may be some states where even the ruling party or a ruling combination may be unrepresented completely as far as the Lok Sabha is concerned, may be unable to bring members to the upper house who are amongst the usual residents of that state. Therefore, in order to make sure in the government also there is representation of those states, there may be a compelling necessity to get some ordinary resident of that state elected from some other state. It has happened in the past. It has happened even today that there is one particular state which was completely unrepresented otherwise as far as the NDA is concerned, both in the Lok Sabha and the Rajya Sabha. and therefore members were got elected from other parts of the country in order to make sure that those states also get a representation in the Council of Ministers. Now with these facts, the government had introduced this bill. There were two views even before the standing committee. The second component of this bill is with regard to the methodology of casting their vote amongst the legislative assemblies as far as the election to the Council of States is concerned. Currently, we have a system where parties put up candidates, but we've had several cases, I've got a list of cases, where in the last few years, we certainly have seen some kind of unusual practices, not very happy for our democracy, which have crept into the polling system. Cross-votings have taken place for reasons which are not entirely political, as a result of which it happened in Maharashtra, it's happened in other states also, where candidates put up by political parties have lost. And in fact, on an earlier occasion, I do recollect when we were discussing the bill for proxy voting for the armed forces, some of the honorable members of this house, Mr. Lalu Yadav and others did mention that there is a great necessity that this procedure itself be changed immediately. And therefore, after consulting a large number of political parties who agreed to this, the second proposal is to bring about a change in the methodology of voting, and the voting as far as Rajya Sabha election is concerned be by an open ballot.
Correct.
Now the procedure for this open ballot, I am very straight here at the very outset, that the procedure for this open ballot is not prescribed in the primary legislation, but would be prescribed as far as the rules are concerned. And the government, in accordance for those procedures, would welcome suggestions from all members of this house today in the course of debate. We would also, after the act is passed, we would welcome suggestions from political parties subsequently as to what that exact procedure could be. We will also consult the Election Commission. One procedure which has been suggested is with regard to at least the recognized political parties all having polling agents, and those who have been elected as members of the Legislative Assembly on the symbol of that political party would be compelled to show their ballot to the polling agent itself. And the rest would be then a matter of the party's own discipline. Some members have even made suggestions whether 10th schedule itself could be extended. But since 10th schedule is a matter which deals with the legislative business, and casting their vote outside it strictly may not, there may not be a need to apply it at this stage, and therefore the consensus being built up was that it's not necessary to apply it at this stage. For the present, the methodology of voting be converted from a secret ballot into an open ballot. The procedure, I can assure this house, we will certainly discuss with the political parties, take their suggestions, take the views of the Election Commission, and only then formulate the procedure. I have given one illustration. This is not a firm view of the government, but this is one possibility. If there are other suggestions, we would welcome those suggestions. One point of criticism which had been made against this procedure itself has been that secrecy of ballot itself is an essential component of every election. This is a point some people have made. And therefore, conversion of a secret ballot into an open ballot may perhaps defeat that purpose of secrecy. Madam, I wish to correct this impression. Elections must be fair. In fact, in relation to the Rajya Sabha elections itself, the Supreme Court in 1980 had an occasion to deal with a situation where a vote was shown to somebody else, and the question raised was that the secrecy has been destroyed and therefore the election itself gets nullified. I'll just read out a paragraph of what the Supreme Court said. This is the case, I don't think the member is present here, of Mr. Raghbir Singh Gill versus Sardar Gurcharan Singh Tora. Secrecy of ballot was mooted to ensure free and fair elections. If the very secrecy of ballot, instead of assuring free and fair elections, strikes at the root of principle of free and fair elections, this basic postulate of democracy would be utilized for undoing free and fair elections, which is the life and blood of parliamentary democracy. If secrecy of ballot, instead of ensuring free and fair elections, is used, as it's done in this case, to defeat the very purpose of election, purpose for which it is enacted, to suppress the wrong coming to light and to protect a fraud on the election process, or even to defend a crime, that is forgery of ballot paper, this principle of secrecy will have to yield to a larger principle of free and fair elections. Therefore, if secrecy is leading to a situation where corrupt practices have overwhelmingly crept into the system, the question for this house, therefore, in this question would be, will this principle of secrecy then have to yield to openness, which may perhaps provide some sunlight, expose those who indulge in these practices, and then leave it to the parties to decide what action they want to take against them. Openness, therefore, by a large number of members has been felt. The matter went to the standing committee. It was chaired by the Honorable Shri Pranab Mukherjee. There were two views on the standing committee, and the committee, therefore, could not come to a firm recommendation as far as this bill is concerned. After considering the recommendations and the various views expressed by the standing committee, the government was of the firm view that it is now time both to change the residence requirement, which was a condition precedent, as also the methodology of voting as far as the Rajya Sabha election is concerned, in order to ensure that the election system becomes much cleaner. With these words, Madam, I commend to this House that this bill be accepted.
Thank you. Shri Pranab Mukherjee.
Thank you, Madam Deputy Chairperson, for giving me this opportunity of sharing my perception with this august House. As the Honorable Minister has referred to, I had the privilege of examining the proposals in the Parliamentary Standing Committee attached to the Ministry of Home, Law and Justice. As it has been pointed out that there were differences, and we have elaborated in the narration part of the report, where we have indicated that members could not come to a conclusion in regard to the rather unanimity or a consensus in regard to both the important provisions of the bill. One is the removal of residential qualification, another in respect of the openness of the voting system. What has been pointed out by the Honorable Minister while introducing the bill, that essence of parliamentary democracy is to conduct free and fair elections, and if money power or muscle power entered into the process of the election.
Sorry, just 1 minute. There's some disturbance. There's somebody has left his mic open. I think we'll have to send a circular to the members. When they leave their seats, they should switch off the mic, because it becomes very disturbing. There is some mic, it's a translation.
Some technological hazard.
Some commentary is going on. Is it so loud? Band karke aao.
Madam, the point which I was trying to drive at, that what the Honorable Minister has correctly pointed out, that the essence of a parliamentary system is to ensure that money power and muscle power do not influence the elector. And unfortunately, there is no denial to the fact. I am afraid we shall have to live with it for some time. I don't know from where it is coming. Anyway, that unfortunately in the recent.
No, it is perhaps either in the press gallery or somewhere else, a television is going on. Because when Mr. Mukherjee stops, still it goes on.
Yeah. That unfortunately in some of the elections recently held in Rajya Sabha, allegation was there that money exchanged, and normally it is expected, and our scheme of representation in the Rajya Sabha is very well construed, and when the system of preferential single transferable voting system was introduced, it was ensured that even the smaller parties could have their representations. But it is really become surprising when if somebody comes in this house without having a single member of his or her party in the legislature, then obviously it is not a very transparent way of coming. This is one problem. Another problem which arose, and unfortunately it is not for the first time. Madam, you will recollect, when our Constituent Assembly was constituted by a resolution, passed by the House of Commons, the members of the Constituent Assembly were also chosen in the same methodology through which the members of Rajya Sabha are elected today. And it happened that some of the very prominent personalities of the Constituent Assembly, they represented the states to which actually they did not belong to. And it happened in respect of both Muslim League, the then important party, and also in respect of some other important personalities. Anyway, the system which continued thereafter, it was found necessary to make the amendment, and as I mentioned that there are two important elements in the proposed bill. One is removal of the residential qualification. The idea behind having this residential qualification that the member representing the states, as it is called Council of States, he must represent the interests of the states. And it was thought that if he belongs to the state as a resident of the state concerned, interests of the states will be properly represented by him. And the counter argument which came that when the electors are the members of the state legislative assembly, and surely they are not going to choose a person who will not be mindful of the interests of the states, and the electors will take care of that. Therefore, the residential qualification need not be observed. And when it was found that some of the members, including myself, madam, represented a state to which I did not usually belong to. This is my sixth term, but in one term, between 1981 to 87, I represented the state of Gujarat. And naturally, I had to issue a declaration by changing my residence. Nothing wrong in changing of the residence. But naturally, eyebrows were raised. Some of the members had more interesting history that in 3 terms they represented 3 different states. First one state, then second term another state, and in third term 3 consecutive terms, a third state.
Good
To avoid.
There must be good travelers.
But let us, I am not, that's why I am not mentioning the name. Therefore, no, the same party. So for the instance which I am referring to.
I am referring to an instance where the member has been representing 3 different parties on consecutive terms and representing 3 different.
No, but whether he is coming from the same state or from the other state.
From 3 different states.
Acha, good. So it has happened sometimes. Therefore, to accept the fact, because political parties find it extremely difficult, if they are to bring some of their important members, and if the state concerned does not have adequate representations, naturally these type of practices are followed by, and almost every political parties have accepted it. So in fitness of the things, it was considered that let us recognize the ground reality and remove the legal hurdles which were there. That was the rationality, and so far this aspect of the bill is concerned, the standing committee made the recommendation that there need not be a residential qualification. And as the Honorable Minister has very correctly pointed out, that we could not come to a conclusion in regard to the openness of the votes. At one point of time, it was considered that whether the vote can take place by pressing the button as we decide in case of divisions. But when it was pointed out that preferences are to be recorded, therefore a ballot is needed, and instead of having a secret ballot, now it will be an open ballot, and surely the government will have to work out a mechanism through which the system of open ballot can remove the questions of having election through unfair means by resorting to money power. But one danger still remains, and surely all laws cannot, all other laws cannot plug all the loopholes. Now here we are taking certain safeguards in respect of the individual members concerned. But if a political party, and the instances are not lacking, if a political party decides to have representations of that political party in consideration of, in certain other considerations, then who is to protect it? This is, and it has happened. I would not mention the names. Names are obvious. It has happened that sometimes some political parties have chosen persons from outside or persons from in the same state, but not for his political contribution, nor for his or her association with the party, but for other considerations. And from day one it has happened. If you look at the list of the first members elected, at that time I think it was not 232, it was 223 or so, you will find that some states, those persons who represented this council of state, represented the different states in this council, all of them were not political activists or social activists. Large number of them were there. But there were some other people who could manage the nomination of the political parties by exercising their influences. Therefore, that is going to take place. And here, I think that unless we create adequate awareness and consciousness within the political system and political establishment, it would be very difficult to prevent that. We are extending our support to this bill, and I do hope a scheme which was envisaged 50 years ago, no doubt though this bill has not evoked that much attention, but we are making a major change in our constitutional process, because one major change would be the open voting. Another major change would be that qualification attached to the member of the Council of States in regard to the compulsion of residing in the state from which he is elected. These are the major changes in the scheme of the constitutional mechanism which we have operated through all these years, and I do hope that with the objective with which these amendments are being brought in will be fulfilled, and in course of time, if we find any other difficulties, of course it would be for this House to make the necessary amendments. With these words, I support the bill. Thank you, Madam.
Shri Singhal, BP Singhal.
Thank you, Madam Chairperson, for allowing me to share my views on this very important amendment, which is coming after 52 years of its practice. And as Honorable Arun Jaitley made all the points in the support of the bill, there's not very much left to be said. But I was very, should I say, amused at the revelation made by Honorable Pranab Dan, that this happened right at in the Constitution of the Constituent Assembly. Now, if that had happened then, I think this amendment, or this amendment which is coming today, should have come right at the beginning. So, as has been said, the bill aims to change make two changes, major, in Section 3 and Section 39, 59, and the remaining two sections of 94 and 128 are merely consequential. Now, regarding the local resident being made redundant in the new amendment, the fact remains that there were states where political parties were not represented at all, and major political parties of the country. Now, every political party naturally has its own views to talk about the problems of each state, but where they do not have any representation or scarce representation, in another state, how is that political party going to voice its own voice in regard to that state? And therefore, this subterfuge was used to get them elected from somewhere, giving them representation here, but he essentially belonged to the state which was going unrepresented till then, so far as that party was concerned. Then came the question of outstanding talent, which sometimes was necessary for being incorporated in the running of the government. And why should not the country use the best of talent in running a government? And for that reason, this subterfuge was again utilized. The third reason perhaps was which is typical to Delhi, where the major and important politicians have made their residences now for years, but there being only 7 limited Lok Sabha seats and just 2 Rajya Sabha seats, all cannot be brought from Delhi state itself. So they had to be brought in from various other states utilizing the same subterfuge. Now when it was so openly being done, and the third point, or the last point was that the Election Commission itself came up in 19 in April, sorry. In April.
आप रुक जाइए.
In April 2001, the Election Commission confessed that there is no definition of ordinarily a resident. Now, with that definition not being there, it became very difficult for the Election Commission to take any action against this subterfuge. Now, as this was going on, as Pranab Das said, considering the ground reality, this change was brought in, and it is just as well that this has been brought in, because very eminent and respectable persons had to more or less declare a lie on an affidavit which is supposed to be filled at the time of elections, that I am a resident of this place, and they know jolly well that they are not a resident of that place. So this amendment will do away with this this compulsion that was compelling eminent persons to state what was not altogether correct. Now, as this was, on the other hand, the second problem started springing up, and that was the problem caused by the slackening of discipline in political parties. Now, they were told to vote for someone, and they just decided not to vote because it used to be a secret ballot. This cross-voting took place perhaps for personal considerations in some cases, but when this cross-voting started for considerations which were directly related to money power, then it was cutting at the roots of the democracy itself. And it is just as well that this second amendment also has been brought in to remove the play of money in the elections to the Council of States. There are any number of instances. Honorable Law Minister has perhaps got a whole tally of such cases where money power has been used and people have not voted together. And it is just as well, sir, that the rules of how this is going to be implemented have yet to be made, because that will be made with the consensus of all the parties. And however, there is no doubt about the desirability of these two amendments. With these words, sir, I commend that the amendments be passed.
माननीय नीलोत्पल बसु.
Thank you, Mr. Vice Chairman, sir. At the very outset, I would like to make it very clear, abundantly clear, that our party had opposed the provisions of this amendment right at the stage of introduction, and we continue to oppose the provisions of this bill. Now, we do not think that our opposition is based on any idea which is not in tune with the times. Rather, we feel that amendments which have been proposed by the government, by the Honorable Law Minister, are actually based on totally misplaced presumptions. Now, at the very outset, I would like to try and, I don't know whether I can actually remove certain misconceptions, factual misconceptions, because Honorable Law Minister, while introducing the bill, moving the bill, was stating that a large number of people who are not ordinarily resident of a state are actually giving false information to actually get enrolled in the voters list in that particular state. And we have been given the very good and factual report by the standing committee, though I do not agree with many of the conclusions, but I cannot really adversely comment on the quality of the report. The report as such is very good. It says on page 1 itself, clause 2.4.1 on this subject, that the committee, while finalizing its recommendations, had asked for the number of such members who were not ordinarily resident but had actually given sort of false certificate. So the legislative department submitted, I quote, to the committee a list of 20 members out of 232 members elected in 6 biennial elections held during the period from 1/1/88 to 28/12/93 as collected from the Election Commission of India. Of course, then it is also qualified by saying which appears to be illustrative and not exhaustive, as complete information as sought by the committee is not available with the Election Commission of India. Now, my point is that if we go into the actual cases, that the total number of such members who are not ordinarily resident of a state but actually giving some kind of a certificate to the contrary will be around 10% of the total members elected in this state. Now, this bill is going to decide the fate of this house, which is otherwise called the Council of States. And at a given point in time, the Council of States captures the complex, the heterogeneous, the diverse political reality of the state, unlike the House of the People. That the actual political reality, the actual cultural, actual reality that is obtaining in the states is expressed in the collectivity of the composition of the Council of States. And that is the idea which was built up in the Constitution. For paucity of time, sir, I do not go extensively into the debates of the Constituent Assembly on this. That why Council of States was needed. When there was a House of the People, when people directly elected their representatives, what was the need for the Council of States? It was precisely to have an expression of the realities that obtained in the states, that a Council of States was needed. Now the question therefore is that members to be elected to the Council of States from particular states, how do they actually qualify to represent those states in the Council of States? What is the necessary requirement? Now hereafter, how will you address this question that a particular member being elected from a state is in a position to adequately represent the concerns of the state? What will be the distinguishing feature? Till now there was a distinguishing feature. Some aberrations were there. But hereafter, how will a particular member claim or appropriately address and articulate the concerns of the state? That answer is not in the amendment. Because if I am not ordinarily resident, I will not be unaware of the problems of that state. I will not be aware of the concerns of the state. How can I articulate, which is one of the fundamental qualifications for me to be a member of the Council of the States? This is a fundamental question which has to be answered. Now the other issue of some members, very honorable members, I mean, who can contribute to the political process, they cannot get elected. You see, these are exceptions which people also have come to accept. I mean, we need not get troubled over that. People know, yes, maybe he is not actually representing the reality, but at the same time, for nation building, for the requirement of governance, those things are to be accommodated. So those things remain. But now what will happen? Once that bar is removed, it will open the floodgates. That is, that my fear is that people who are not ordinarily resident of a particular state will come in the majority representing those states. Is there any remedy in this bill that you will debar people who are ordinarily resident of a particular state, they become minority insofar as representing their state in the Council of States? There is no doubt about that. Because the instance that Pranabda was citing and the instance I was citing, I also will not name. I know a member representing 3 different states and representing 3 different parties on consecutive terms. How do you stop that? When you come to the core of the problem of our democratic system today, the problem is not in the form, it is in the content, it is in the substance. What is the definition of a political party? A political party is a voluntary organization of individuals who have voluntarily joined a political party on the basis of certain ideology, on the basis of a program, on the basis of a set of policy issues. Now, if in a democratic polity, if you have a situation where individuals who have voluntarily joined a political party are no longer attracted by the ideology, program and the set of policies of that party and exercising their choice on the basis of extraneous considerations like money, can that basic malady of the political system be remedied by legitimizing that wrong practice? Cannot be. And I think, I mean, we should introspect, we should ponder over this, because I mean, any textbook of democracy anywhere in the world, that universal adult franchise and secret ballot, these are the 2 essential ingredients of democracy. Why? Because as opposed to dissent or dissidence, difference of opinion is an essential ingredient of democracy. Therefore, open ballot, which is to stifle difference of opinion, is something which is antithetical to democracy. Therefore, we are actually striking the very roots of a very significant feature of the democracy for the sake of our own convenience. सर थोड़ा 2-3 मिनट विरोध में बोलने वाले ज्यादा नहीं है, तो इसीलिए बिल तो पास हो गए, मेजर पार्टीज दोनों एक हो गए इस सवाल पे, थोड़ा दूसरा बात को. So I'm saying that how to do that? Because this amendment has this great pretension of upholding a very lofty ideal that we are going to stop the influence of cash power in politics. We are going to stop horse trading. But I say that from retail horse trading you will go to wholesale horse trading. Instead of buying individual members from a party to vote for a particular, that is what I am saying. That you switch over from a retail horse trade to a wholesale horse trade. That you buy up smaller parties, 4-member, 5-member parties, and you get elected. So, I think therefore the pretensions on which this bill is premised, I think it is totally misplaced, because the kind of things, because we have political parties who go with a manifesto, who go with a certain program, who go with a particular commitment that after getting elected, we will never ally with that particular party to come to power. And the very next day, that very same party allies with that very party with whom it was never to ally to come to power, but it comes to power. The confidence that the people, the electors bestow on that party is being betrayed. Now, if you have legitimized the party or the government which has legitimized such practices and it claims that by having this practice we are going to completely cleanse the system from the influence of cash or other opportunism, I think it is a bit too much for me to digest. It is like that Hajmola advertisement. कोई दिखाया जाता है कि कोई बच्चा अपना सपना में बॉलिंग कर रहा है तो बोला ऐसे आउट कर देंगे, कपिल देव पहुंच जाता है, मतलब ये कुछ हजम नहीं हुआ. वो ऐसा ही बात है कि दूसरे पार्टीज के साथ वो अलाई कभी नहीं करेंगे, ये वादा करके लोगों से वोट लेके फिर वो करते हैं. तो इसीलिए ऐसे पार्टी है हमारे देश में जो ये काम कर सकता है, वो भी पैसा लेके दूसरे जिसको नहीं लाना चाहिए ऐसे लोगों को ला सकते. Therefore, my point is that we should seriously introspect as political parties that how the principles on which in a political process the political parties function, how we can rectify that process. How we can recapture certain healthy practices in politics. Now, we are knocking at the wrong doors to really address our own problems. The problem of indiscipline, the problem of dissidence can never be stopped in this manner unless we improve our system of internal democracy, unless we have healthy practices of free and fair discussion in the parties. If we use democratic practices to evolve the candidatures, you can never stop this. This will continue and this will continue to ail the political system. Therefore, sir, with all humility we say that the reasons that are being cited are very wrong and there is no answer that how a member will establish his or her credential to effectively, appropriately articulate the concerns of a state, that distinguishing, what will be that distinguishing quality that member will be having in the post-amendment regime, that also there is nothing. Therefore, I think I cannot accept this because today another important feature is emerging in Indian politics. That is, we have large number of federal, regional parties coming up. Federalism is a big question in our country today. Therefore, unless we strengthen that process whereby there is cooperative federalism, I mean, there's a problem. Therefore, all those distinguishing features, without substituting that feature with a even more improved manner in which a person is better, can more appropriately represent a state. If whatever existing distinguishing feature is there, if we abolish that, that will be a very major setback to the process of federalism that is developing in this country. Therefore, sir, from no count, I mean, looking at the current requirements of the political process and current difficulties that the political system is faced with, I think that this bill is going to help us in our problems in politics overall, or in better constitution of the Council of States, which is a very, very important institution as has been envisaged by our constitution makers. Therefore, we oppose this bill with whatever strength we have. Thank you, sir.
माननीय श्री रामचंद्रैया नहीं है, माननीय कपिल सिब्बल.
Thank you, Mr. Vice Chairman, for giving me this opportunity to place my thoughts on this proposed legislation. Mr. Chairman, sir, there are two separate issues which are incorporated in this amendment. The one relates to change of residential qualification and the other relates to the manner of voting for representation to the Council of State. So I'll take up each of them separately. I have to say that I have listened with rapt attention to what my good friend Nirotpal Basu had to say on the proposed amendments, and I'd like to place my thoughts on it. First of all, the residential qualification. I do believe, sir, that there was essentially a lacuna in the original legislation dealing with this. Because if you look at the definition of the term ordinary resident, that definition did not come about in the 1951 Act. The term ordinarily resident is used in the 1950 Act. And the 1950 Act deals with not the process of election, but it deals with the preparation of electoral rolls. So what used to happen is, and this is the anomaly, what used to happen is that without anybody knowing, a person who wanted to become elected from a particular state used to quietly go himself and enroll in that particular state, much before the election. And under the rules, you have to be ordinarily resident at least for 6 months. So prior to 6 months, he used to enroll. Now, at the time of enrollment of a particular person in the electoral roll, nobody comes to know, because there may be some notice, but the other political parties don't even have any idea as to whether a particular person is going to fight an election 6 months down the road. So once the name is entered in the electoral roll, as far as the test of ordinarily resident is concerned, that's complete, that's final. What happens thereafter is the election. And at the time of the election, a person has to file his nomination paper and then has to file a copy of the electoral roll. Now, copy of electoral roll is proof of residence. So at the time when the nomination paper is scrutinized under section 39 odd of the Representation of People Act 1951, nobody can question at that time that you are not ordinarily resident in this state, because that cannot be the subject matter of challenge, because as far as the returning officer is concerned, he looks at your electoral roll, you have a particular number there, and your name is entered. That inquiry cannot be gone into at that stage. So automatically the election takes place. Now, once the election takes place, as you know, the grounds of challenge to that election are set out again in the Representation of People's Act, and the grounds of challenge, which are set out in section 8 and 8A of the Representation of People's Act, as well as under the Constitution, do not allow as a ground the issue of residence. In other words, a person who files an election petition cannot challenge the election of a candidate on the ground that he was not ordinarily resident in that state from which he sought election. That's not a ground. So the result was that there was no adequate machinery under the Representation of People's Act to challenge the issue of residence once a person got elected. And therefore, people used to go to those states much in advance, get their names entered in the electoral roll, get themselves elected, knowing full well that the issue cannot be challenged in a court of law. So the remedy for Mr. Basu is not to oppose this, but to say that you should have another law by which the issue of ordinarily resident can be questioned under the Representation of People's Act to challenge the election. But that's not what he is suggesting. If my good friend is really genuine and really concerned about this issue, then 51 years have passed. His party should have brought an amendment under the Representation of People's Act and proposed that that challenge should be made available to an election petitioner challenging somebody's election on the grounds of residence. Now, sir, if you remember, and it takes me back a few years, there was a chief election commissioner who got very concerned about all this. And he started writing off letters to various people in various states and also to candidates saying, please let me know how you are ordinarily resident. Why? Because the chief election commissioner thought it was his jurisdiction to find out whether he was ordinarily resident or not, knowing full well that in a court of law that's not permissible. So, my good friend's intentions are correct, his concerns are correct, but he is approaching it the wrong way.